Hi everyone, let's look at consideration and promissory estoppel. In this chapter, we'll look at the definition of consideration, describe the requirements of consideration. We'll define a gift promise and identify whether gift promises are enforceable. We'll describe contracts that lack consideration, such as those involving illegal consideration, an illusory promise, a pre-existing duty, or past consideration. We'll also list and describe special business contracts, including output contracts, requirements contracts, and best efforts contracts. Finally, we'll define accord and satisfaction in settling a disputed claim and define and apply the equitable doctrine of promissory estoppel. So before we jump right into the core of the material, let's look at a couple cases and see if you can tell the difference between the two. In the first one, Doherty versus Salt, this happened in 1919. An elderly aunt writes a note to her nephew promising $3,000 at her death or before. The aunt dies and the estate won't pay. Keep in mind that $3,000 in today's dollars would be, probably closer to $100,000. So it's quite a bit of money. So the aunt dies and the estate won't pay, and then the nephew sues. And there's a question about whether the court should uphold the agreement that this aunt and her nephew had. So let's contrast that with a different case, Hamer versus Sidway. This happened in 1891. A man promises his nephew that he would pay him $5,000, which would equate to about $150,000 in today's dollars, if he refrains from drinking, using tobacco, swearing, and playing cards or billiards for money until he became 21 years of age. So the nephew agrees and performs the conditions. Upon the uncle's death, he tries to enforce the agreement, but the estate won't pay. It goes through many levels of court before we finally get a decision. And then the question essentially is, should the nephew be able to enforce this promise? So do you see a difference between these two cases? We'll circle back to those at the end to tell you what the difference is. So let's define consideration. Consideration is something of legal value given in exchange for a promise. Consideration is necessary for the existence of a contract. The elements have to be something of legal value must be given, and there must be a bargained for exchange. Legal value is interpreted pretty broadly. The basic idea is that the promisee would suffer a benefit or a detriment. The promisor would also suffer a benefit or a detriment. Bargain for exchange is the process of bargaining or inducement that leads to an enforceable contract. Bargain for exchange is naturally present in most business contracts. The basic idea is that somebody offers consideration to somebody in exchange for a promise, and that person, being enticed by that consideration, makes a promise of their own. What are the types of consideration? The most common, of course, would be money, something of legal value. Also property, that can be personal property or real property. The performance of an act, included in many services, and forbearance, which is refraining from doing something that I have the legal right to do. So one example might be a part of a lot of contracts and settlement agreements is a promise not to sue or not to pursue anymore, or maybe a promise not to talk about it in public, promise not to disclose any of the terms of that contract. So these kinds of promises are called forbearance. They don't necessarily require that I act on a certain, they don't require that I do a certain thing other than, not disclosing something. So to illustrate legal benefit and detriment, we've created a scenario here where we have John is going to be selling his car to Jane, who's going to be buying it from John. So the detriment that John is going to suffer is that he will no longer have his car once this deal is closed. The benefit, however, is that he gets money in exchange for his car. The detriment that Jane will be suffering is that she has to part with her money, but the benefit is that she gets a car. So it's a pretty simple concept once we illustrate it. Okay, so a case study involving another inheritance. So we have two siblings who are kind of on shaky terms with their mom for their whole life, and they're afraid that one of them is going to be written completely out of the will upon her death. So what they do is the two siblings, brother and sister, get together and agree that once mom dies, they're going to split the inheritance equally among the two, even if one of them gets written out of the will. So this happens, and we find out that Ferguson has been written completely out of the will. So he goes to the sister and tries to enforce the agreement that they had to split the inheritance, and she refuses. So we have a lawsuit on our hands. Issue was the oral promise supported by consideration? Well, all we had was a promise to split this inheritance. So was there a benefit that either one of them would have gotten? Of course, the benefit would be getting money. What would be the detriment? Either party could have suffered a detriment of having to give up half the money if they got it all. So the court said yes. The oral promise was supported by consideration, so it enforced the agreement that the two siblings had. So what about giving somebody a gift? If somebody promises to give me a gift and then they don't do it, can I sue them for that? A gratuitous promise is one, well, it's a kind of gift promise where somebody's not doing something in exchange. I'm just giving them something out of the goodness of my heart. A gratuitous promise is unenforceable due to a lack of consideration. They haven't done anything to deserve that money. I just chose to give it to them. Before I give them that gift, if I choose to back out, they would have no way to enforce that really. However, once I do give them the gift and they accept it, that gift promise is not revocable anymore. So I give something to somebody, they receive it. I can't then go back and demand to get that property back because now it's theirs. So in this case study, we have a guy who gets into a car wreck. He's laid up in the hospital for quite a while. During the meantime, a girl comes by and visits, and her mom comes along a lot of the time. They visit him in the hospital, take care of him, form good relationship with him. Once he gets out of the hospital, he goes to live with his girlfriend and her mother. During that time, he he eventually got a $180,000 settlement out of the wreck to help pay for his injuries and pain and suffering. And out of that $180,000, he bought a lot of stuff for the two ladies. Julie was his girlfriend and Janet was her mother. She got Julie an engagement ring as part of proposal for marriage. He bought Julie a car, a computer, a tanning bed, some horses, paid off Janet's car, got a new furnace for their house, and installed new flooring in their kitchen. Now the relationship went sour. They broke off the engagement. Cooper moved out, and now he wants all the stuff back that he gave them. Okay, so we have an issue here. Broken heart, want to get back all the stuff we gave somebody during the course of a relationship, and the question is, can he go and demand that property back? Unfortunately for him, the stuff that he gave them, that gift, once it's been completed, is not revocable, and that property is just theirs. The one big exception being the engagement ring. In most states, an engagement ring is considered to be a conditional gift, the condition being that marriage take place. And since they hadn't gotten married, once the engagement's broken off, the ring is supposed to go back to the person who bought it. So, the reality of actually getting it from somebody whose heart has been broken could be, difficult, but the legal right to the engagement ring goes back to Cooper. Everything else, once he's given him those gifts, belongs to Julie and Janet Smith. So what kind of promises lack consideration and would not be the foundation for an enforceable contract? One, of course, is illegal consideration, promising to do anything illegal or even promising to refrain from doing something illegal. Neither one of these will provide consideration for an enforceable contract. Also, an illusory promise. that an illusory promise would be something like, I promise to give everybody in the class an A unless I decide not to, or I promise to buy your car from you unless I change my mind. It almost sounds like I'm making a promise, but I'm not really. I'm not really being nailed down to anything firm. So if I can just choose to back out whenever I want to, it's not really a promise after all. So the promise is illusory. Pre-existing duty, another promise that would lack consideration, would be promising to do something that I already have an obligation to do. If I try to make that part of a new contract, it's not going to be valid consideration for that new agreement. So if I promised to, if everybody gives me $100, I promise to teach extra well. That would not be consideration for a new contract, and I would probably get fired. But I already have an existing duty to teach to the highest standard that I can, anyways. So that would be a pre-existing duty I have. I can't then take that and then try to charge you extra money for it. Likewise, past consideration, something I had already done in the past without expectation of payment. So we're getting ready to move houses, which will be an interesting thing in the coronavirus scare that everybody has right now. But let's say I enlisted the help of a friend to come help me move. Not promising them anything, but they help me move, which is a lot of labor and a lot of annoyance, and takes a long time. But at the end of the day, after all the work had been done, I say, thanks, I really appreciate that. I think I'm going to give you $100 for your trouble. Okay. And then let's say I try to back out of that later, and then they sue me to get the $100 that I promised them. They're probably not going to win because they had already done the act of service out of the goodness of their heart with no promise of anything in return. That act had already been performed before there was any promise of payment. So my promise of payment will not be enforceable because they, starting at that point, hadn't offered any consideration to form an enforceable contract. In this case, we got a guy named Clemens who's working for the Kansas City Chiefs football club. And the Kansas City Chiefs came to him one day and wanted him to sign an arbitration agreement, a binding arbitration agreement. Basically, if he had any kind of dispute with the football club, that he wouldn't go to traditional court. He would submit the claim to arbitration and try to settle it that way. So later on, he has a dispute with the company. He tries to sue him. They counter, try to get the case thrown out on the grounds that he had an arbitration agreement in effect and shouldn't be allowed to sue in court. His argument is that there was not sufficient consideration to form a legally binding arbitration agreement, which would be its own separate contract, and thus it can't be enforced against him. Upon inspecting it in court later on, we find out that the Chiefs didn't really make any promise or offer anything to him in exchange. They didn't bind themselves to arbitration. They didn't offer him any extra money. They just made him sign the agreement. One thing we've learned about arbitration agreements is there has to be valid consideration offered in order for that to be enforceable. So it could be offering money. If you're applying for a job and you're trying to get a new job, even the offer of a job could be considered valid consideration for an arbitration agreement. But the KFC Chiefs did not offer anything. I called them KFC. I don't know why. KFC is fried chicken. This is the Kansas City Chiefs football. But anyway, the arbitration agreement was not enforceable. There are some special kinds of contracts where the consideration might be a little bit weird. We talked about this a little bit in the last chapter, but an output contract is a type of contract where I agree to sell all of my production to a single buyer. It's a kind of an exclusivity contract. It's interesting just because the amount of consideration isn't completely definite in terms of absolute units. It's flexible depending on how much I can actually produce. A requirements contract is a similar concept, a kind of exclusivity contract where I agree to buy everything I need from one supplier. A best efforts contract, we see these sometimes where, for instance, I'm going to keep using my house sale as an example. Now, right now, there's a lot of uncertainty in the market because of the coronavirus scare, and a lot of people are being forced to stay at home, and a lot of businesses are closing. So there's an addendum that North Carolina realtors have added into real estate contracts now where people are supposed to do their best efforts at performance. So the seller is supposed to perform, give his best effort at trying to get an inspection and appraisal and everything done within the due diligence period. I'm supposed to give my best effort to have the house ready and to have the house vacated by the closing date so that the buyer can move in, understanding that there's a lot of uncertain things out there right now, and it might not be possible for us to close this deal. We're going to try the best we can. If it ultimately came to court to try to figure out if somebody gave their best effort, they would probably evaluate it through a reasonable person standard. What would a reasonable person have done in those circumstances, given what everything that's going on in the economy right now? A settlement of claims happens very, very often when there's some kind of dispute, and if we don't let it go all the way to a court decision, we can meet ahead of time and settle anywhere along the way, even before it gets to court or anytime before the final court decision, sometimes even after. We can have a settlement of claims where the parties sit down and come to some kind of agreement to go ahead and settle the matter and get it behind them. A lot of times this settlement is going to end up with one party, one or more parties getting less than they were actually due, and they agree to the settlement just to get as much as they can, and not take the risk of getting less than that or maybe even nothing. We call these types of agreements accord and satisfaction, or at least accord and satisfaction are part of settlement claims. The accord is the agreement where parties agree to accept less than what they were actually going to get, or at least different, to satisfy the original contract. And satisfaction is the performance of an accord. If the accord is not satisfied, the other party can sue to enforce either the accord that they reached or the original contract. So an example might be if I owe a bunch of money on a credit card and I just don't have any money and I'm on the brink of bankruptcy, I might be able to call the credit card company and say, look, I'm behind on payments. I don't have this money. If you sue me, I'm just going to declare bankruptcy and you're probably going to get nothing. So what if we settle on an amount less than what I actually owe, and will you discharge the remaining debt? And depending on my situation and depending on their mood that day, they might actually agree to this. It happens a lot, especially when debt is older and really deep into default and where it looks like you might not get anything. Credit card companies or the people that buy credit card debt might settle that. So the accord would be where we say, I owe 10,000, but I'll give you 6,000 and let's try to settle, or I give you 3,000, let's try to settle. That agreement is the accord, and if I actually pay, and then the debt is discharged, that's our satisfaction. Promissory estoppel is an equitable doctrine that prevents the withdrawal of a promise by a promisor if it will adversely affect a promisee who has adjusted his or her position in justifiable reliance on the promise, also known as detrimental reliance. In order to have a successful case, or at least a shot at a successful claim for promissory estoppel, you have to prove that a promisor made a promise. The promisor should have reasonably expected that the promisee would rely on that promise. The promisee actually relied on the promise and engaged in some kind of action or forbearance of a right of a definite and substantial nature. In other words, they put themselves in the position where they stand to suffer a loss. and injustice would be caused if the promise were not enforced. So you can think of promissory estoppel as stopping somebody from backing out of a promise or breaking a promise. So one example I give pretty commonly is I had an aunt one time who was working for a guy in Colorado, and the guy chose to move his business out to California. And he told my aunt that if she moved out to California, that he would hire her there and pay her more money. So she made plans to move out to California and work for the guy. Now, what if she got all the way there to California, incurring a great expense in moving all of her stuff from Colorado to California, only for this guy to back out of this promise and not give her a job? Well, she might have a case for promissory estoppel because he made her a promise, expecting that she would actually rely on it. She did rely on the promise. She put herself in a position, engaging in an action that cost a lot of money for her, and it would be unjust to allow him to back out of that promise. So she potentially could have a case. In her case, it worked out. Everything was fine. Another case study to illustrate promissory estoppel is East Providence Credit Union versus Jeremia. In this case, the credit union issues a loan to purchase a car to the defendants. Part of the loan was that they required accident insurance to be placed on the car, and they warned that if the defendants don't purchase insurance themselves, that the credit union is going to buy it and bill the defendants for it. Now, the defendants never actually purchased insurance, and neither did the credit union. The car is wrecked. Neither party bought insurance, so somebody's going to suffer a loss, and now we have to figure out who it's going to be. The court ruled that the bank's warning was a promise on which the defendants reasonably relied, and the bank was thus liable under promissory estoppel. So the bank was the one that suffered the loss rather than the defendants, because the credit union made that promise, they relied on it, and there we go. So now let's review those cases that we looked at the very beginning of the chapter here. Doherty versus Saul. So an elderly aunt writes a note to her nephew promising $3,000 at her death or before. Aunt dies, the estate won't pay. Nephew sues. Should the court uphold the agreement? The answer is no. That was a promise for a gift, a gratuitous gift, because the nephew's not doing anything in return. So he would not be able to uphold that agreement in court. Let's look at the next one, Hamer versus Sidway. This is where the man promises nephew money if he refrains from drinking, using tobacco, swearing, playing cards, or billiards for money until he became 21. This one is different because the nephew actually did something. He offered consideration in the form of forbearance, not doing something that he had the legal right to do. So in this case, it had to go through a couple levels of appeal before we finally got a decision. But the court actually did enforce the agreement between the uncle and the nephew. The uncle made a promise to pay money. The nephew promised to refrain from doing something that he had the legal right to do. You know, times were different then, ages were different. Yeah, the court ruled that the nephew could actually get that money from his uncle's estate. That wraps it up for this chapter. Have a good day.